If you're a landlord, property manager, or tenant screening provider anywhere in the United States, there's something you need to understand. Tenant screening is not just governed by one federal law. Yes, the Fair Credit Reporting Act is the federal foundation, and every landlord in every state must comply with FCRA. But on top of that federal baseline, a growing number of states and cities have enacted their own tenant screening laws that add requirements, restrictions, and obligations that go far beyond what FCRA requires. Violating these laws, even unintentionally, can result in lawsuits, fines, and fair housing complaints. That's what this series covers. At tenantscreeningbackgroundcheck.com, we've created individual videos and comprehensive written guides for all 50 states, Washington, D.C., and Puerto Rico, breaking down the tenant screening regulations that apply in each jurisdiction. Whether you screen one applicant a year or thousands, knowing the specific rules in your state is essential for staying compliant and avoiding liability. Let's start with the federal foundation. The Fair Credit Reporting Act establishes the baseline rules that apply everywhere. Under FCRA, landlords must have a permissible purpose to pull a consumer report, and evaluating a rental application qualifies. The applicant must provide written consent before the landlord can access their credit report. If the landlord denies the application based on information in a consumer report, the landlord must provide an adverse action notice, telling the applicant which consumer reporting agency provided the report, that the agency didn't make the decision, and that the applicant has the right to dispute the information and obtain a free copy of the report. These FCRA requirements apply in every single state. But here's where it gets complicated. Many states have added their own layers on top. Application fees are one of the most commonly regulated areas. A growing number of states cap how much a landlord can charge an applicant for the screening process. California caps application fees at the actual cost of obtaining the screening report. New York limits application fees to $20. Washington State limits the fee to the actual cost of the screening. Wisconsin limits screening fees to $25. Other states have their own caps or formulas. In states without a cap, landlords can generally charge whatever the market will bear, but the fee must be disclosed and should be reasonable. Criminal history is one of the most rapidly changing areas of tenant screening law. A growing number of states and cities have enacted what are commonly called ban-the-box or fair chance housing laws that restrict how landlords can use criminal history in screening decisions. These laws take several forms. Some jurisdictions prohibit landlords from asking about criminal history on the initial application. The landlord can only inquire after making a conditional offer. Some jurisdictions limit the look-back period, meaning the landlord can only consider convictions within a certain number of years, typically 7. Some jurisdictions require individualized assessment, meaning the landlord cannot apply a blanket policy of rejecting all applicants with criminal records, but must instead evaluate each applicant individually, considering factors like the nature of the offense, how long ago it occurred, and evidence of rehabilitation. And some jurisdictions distinguish between arrests and convictions, prohibiting landlords from considering arrest records that didn't result in a conviction. Cities like New York City, Seattle, Portland, San Francisco, and Chicago have enacted some of the most restrictive criminal history screening laws in the country. In these cities, the rules are detailed, and the penalties for non-compliance are significant. Our state guides cover both the state-level requirements and the major local ordinances that may apply. Source of income protection is another area where the law varies dramatically. A significant and growing number of states and cities prohibit landlords from discriminating against applicants based on their source of income, meaning landlords cannot reject applicants simply because they pay with housing choice vouchers, Social Security, disability payments, child support, or other lawful income. States with source of income protection include California, New York, New Jersey, Oregon, Washington, Connecticut, Massachusetts, Colorado, Minnesota, Maryland, Delaware, and others. plus dozens of individual cities in states that don't have statewide protection. In jurisdictions with source of income protection, a landlord who screens out all voucher holders or rejects an applicant solely because their income comes from disability payments is committing housing discrimination, regardless of the applicant's qualifications. Credit report usage has its own set of state-specific rules. While FCRA governs the basics, some states have added requirements around how credit information can be used in housing decisions. Some states require landlords to provide applicants with a copy of the credit report upon request. Some states have enacted stricter consent requirements, going beyond FCRA's written authorization standard. And the way credit data interacts with other screening criteria varies by jurisdiction. Adverse action procedures also vary. FCRA requires a basic adverse action notice, but some states require additional disclosures, longer timeframes for the applicant to respond, and specific content in the notice. Landlords who use a one-size-fits-all adverse action letter without tailoring it to their state's requirements may be out of compliance. Some of the most important state-by-state differences we cover in this series include whether the state has an application fee cap and the specific limit, whether the state has criminal history restrictions and the specific requirements, including look-back periods, individualized assessment mandates, and arrest versus conviction distinctions, whether the state has source of income protections, whether major cities in the state have enacted local screening ordinances that add requirements beyond state law, the specific adverse action procedures and timelines, and the penalties for noncompliance, because in some states, violations carry significant statutory damages, attorney's fees, and potential fair housing liability. For landlords, the practical takeaway is critical. You cannot use the same screening criteria everywhere. A screening process that's perfectly legal in Texas may violate the law in New York City. A criminal history policy that's compliant in Alabama may expose you to liability in Seattle. And an application fee that's reasonable in Florida may exceed the cap in California. You must know the rules that apply in each jurisdiction where you own or manage rental property. For tenants, the practical takeaway is equally important. You have rights in the screening process, and those rights vary by state. You have the right to know why you were denied. You have the right to dispute inaccurate information. In many states, you have the right to be evaluated individually rather than rejected by a blanket policy. And in a growing number of states, you have the right to not be discriminated against based on your source of income or criminal history that meets specific criteria. Every state guide in this series covers the specific statutes, requirements, restrictions, and penalties that apply in that jurisdiction. We've included information about major local ordinances in cities with their own screening laws. To find your state's complete tenant screening law guide, visit tenantscreeningbackgroundcheck.com and look for our tenant screening laws by state page. We have all 50 states, Washington, D.C., and Puerto Rico covered with detailed written guides and video walkthroughs. And if you need a fast, fully compliant tenant screening or background check, we've got you covered. Visit tenantscreeningbackgroundcheck.com. No account needed, no subscription, results delivered quickly, and fully FCRA compliant. Subscribe to our channel for every state in our tenant screening law series, plus our habitability laws, lease termination laws, rent increase laws, and eviction notice law series.